Near the end of his opinion on executive immunity, Chief Justice John G. Roberts, Jr. pooh-poohed the fears of his liberal colleagues who worried in dissent that the broad protections the Supreme Court had conferred on former President Donald J. Trump would place future presidents beyond the reach of the law. The real concern, Chief Justice Roberts said, was not that immunity would embolden presidents to commit crimes with impunity, but rather that without it, the country's rival leaders would endlessly be at each other's throats. The dissents overlooked the more likely prospect of an executive branch that cannibalizes itself, he wrote, with each successive president free to prosecute his predecessors. That dark vision, however right or wrong it proves to be, did not come out of nowhere. It was offered to the court by Mr. Trump's own lawyers during oral arguments on the question of immunity that took place in April. The justices in the majority said their decision was not just about Mr. Trump, but it was impossible to separate it from the possibility of a second Trump presidency following a campaign in which Mr. Trump himself has promised unabashedly to use the legal system as a weapon of political retribution against President Biden and other foes, whom he accuses of having unfairly targeted him for prosecution. In many ways, the court's decision was something like a Rorschach test for the justices, revealing what they saw as the largest looming threat to American democracy. For the conservatives, that threat is the prospect of ceaseless cycles of partisan prosecutions constraining a president's ability to make decisions in the best interests of the country. The main concern, the Chief Justice wrote, was to insulate a president from the perils of hesitation to execute the duties of his office fearlessly and fairly because of a fear of prosecution. The liberals, by contrast, feared a monarchical president who could use the immense powers of the office for personal or political gain or for other illegitimate purposes without the legal checks and balances that they say have long been necessary to ensure accountability. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends, Justice Sonia Sotomayor wrote in her scathing and occasionally sarcastic dissent. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Overall, the ruling reflected just how far the court's conservative majority, which Mr. Trump helped to expand, has gone in endorsing his view of politics as a no-holds-barred battle for power and his contention that American leaders will, as a matter of course, now seek to prosecute their rivals. Trevor Morrison, a professor at the New York University School of Law, agreed that the court's decision focused a spotlight not only on what the justices feared about the future of the country, but also on the central principles they held as federal jurists. The two sides differ greatly in what they saw as the chief danger that each wants to protect against, he said. But you can also contrast their values, with the majority wanting the presidency not to be undermined by constant prosecutions and the dissenters showing concern about ensuring the rule of law. These two different views about the nature of politics and power were far more than a mere philosophical dispute among the justices. The way in which the court decided the immunity case could soon have real effects on the ground. Mr. Morrison, for example, imagined what might happen if Mr. Trump were re-elected and appointed a pliant attorney general to go after Mr. Biden. The majority on the court would likely say that Biden enjoys a wide sweep of immunity from prosecution, Mr. Morrison said. But at the same time, no one would be able to go after Trump for weaponizing the Justice Department. Mr. Trump's lawyers first presented their idea that in the future, former presidents will be relentlessly pursued by their successors in written filings to the court. But their fullest articulation of that stance came during the court's oral arguments. That was when D. John Sauer, who argued before the justices on Mr. Trump's behalf, asked them to imagine someone, Mr. Trump was not identified by name, prosecuting Mr. Biden for his immigration agenda. Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? Mr. Sauer asked. Answering his own question, Mr. Sauer envisioned a world of constant legal tit-for-tat, asserting that it would destroy the presidency as we know it. And several of the court's conservatives appeared to agree that world was on its way, or perhaps already here. Justice Samuel A. Alito Jr., for example, expressed concern that without some form of criminal immunity, former presidents would be highly vulnerable as their successors used the courts to go after them once they were out of office. And that, he added, could lead to persistent cycles of retribution that would present a risk to a stable, democratic society. Mr. Trump has long and baselessly maintained that it is Mr. Biden and his Democratic allies who politicize justice by pursuing him with multiple indictments even as they have faced each other on the campaign trail. But in advancing those claims, Mr. Trump has never acknowledged the reality that no other president has been faced with as many allegations or as much evidence of wrongdoing as he has. In its ruling, the Supreme Court's majority tacitly bought into Mr. Trump's portrayal of himself as a victim of partisan legal warfare, if only by endorsing his vision of a world where presidents would ruthlessly use their powers to go after their predecessors. That bleak view was also in keeping with another of the former president's longest-held beliefs that there are no good guys in the world because everyone is corrupt. Against that dystopian vision, the liberal dissenters, particularly Justice Sotomayor, asserted the idea that immunity was unnecessary to protect a former president against partisan indictments, since the job could effectively be handled by all the protections our system provides to criminal defendants. Justice Sotomayor reminded the conservative majority that it was not exactly easy to indict a former president, a proposition that seemed in keeping with the amount of time and angst it required to bring charges against Mr. Trump and the subsequent difficulty prosecutors have had in advancing those cases. There were built-in checks and balances, Justice Sotomayor went on to say, to stop a prosecutor from bringing cases without merit. She cited the grand jury process, for example, the ability to file motions to dismiss, and the burden of proof that prosecutors must assume at trial. But Chief Justice Roberts seemed to play down the suggestion that any normal legal roadblocks could slow a partisan prosecutor on a mission to indict a political rival, claiming that immunity was needed because, by its very nature, it stopped prosecutions from ever reaching a courtroom. He also seemed to reject the Justice Department's assurances, echoed by the dissenting liberals, that prosecutors and grand juries will not permit political or baseless prosecutions from advancing in the first place. As he put it, "We do not ordinarily decline to decide significant constitutional questions," he wrote, based on the government's promises of good faith. Several justices seem to want to define some level of official act as immune. Although Mr. Trump's claim of near absolute immunity was seen as a long shot intended primarily to slow the proceedings, several members of the Republican-appointed majority seemed to indicate that some immunity was needed. Some of them expressed worrying about the long-term consequences of leaving future former presidents open to prosecution for their official actions. Among others, Justice Brett Kavanaugh compared the threat of prosecution for official acts to how a series of presidents were hampered by independent counsel investigations, criticizing a 1984 ruling that upheld a now-defunct law creating such prosecutors as one of the Supreme Court's biggest mistakes. Chief Justice John G. Roberts, Jr. criticized an appeals court ruling rejecting immunity for Mr. Trump, saying he was concerned that it did not get into a focused consideration of what acts we are talking about or what documents are talking about. The Democrat-appointed justices, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, asked questions indicating greater concern about opening the door for presidents to commit official crimes with impunity. The arguments signaled further delay and complications for a Trump trial. If the Supreme Court does place limits on the ability of prosecutors to charge Mr. Trump over his official actions, it could alter the shape of his trial. A decision to send all or part of the case back to the lower courts could further slow progress toward a trial, increasing the odds that it does not start before Election Day. Of the matters listed in the indictment, some, like working with private lawyers to gin up slates of fraudulent electors, seem like the private actions of a candidate. Others, like pressuring the Justice Department and Vice President Mike Pence to do things, seem more like official acts he took in his role as president. At one point, Justice Amy Coney Barrett suggested that prosecutors could simply drop Mr. Trump's arguably official actions from their case and proceed to a swift trial focused only on his private actions. And D. John Sauer, the lawyer for Mr. Trump, told the court that no evidence of Mr. Trump's official actions should be allowed into the trial. But Michael R. Dreeben, a Justice Department lawyer arguing on behalf of the special counsel's office, said the indictment laid out an integrated conspiracy in which Mr. Trump took the official actions to bolster the chances that his other efforts to overturn the election would succeed. He argued that, even if the court holds that Mr. Trump has immunity from liability for his official actions, prosecutors should still be allowed to present evidence about them to the jury because the actions are relevant to assessing his larger knowledge and intentions, just as speech that is protected by the First Amendment can still be used as evidence in a conspiracy case. The hearing revolved around two very different ways of looking at the issue. Looming over the hearing was a sweeping moral question: what effect might executive immunity have on the future of American politics? Not surprisingly, the two sides saw things very differently. Mr. Sauer claimed that without immunity, all presidents would be paralyzed by the knowledge that once they were out of office, they could face an onslaught of charges from their rivals based on the tough calls they had to make while in power. He pictured a dystopian world of ceaseless tit-for-tat at political prosecutions that would destroy the presidency as we know it. Envisioning the opposite scenario, Mr. Dreeben worried that any form of blanket immunity would place presidents entirely outside of the rule of law and encourage them to commit crimes, including bribery, treason, sedition, even murder, with impunity. The framers knew too well the dangers of a king who could do no wrong, he said. Both sides found advocates for their positions on the court. Justice Samuel A. Alito Jr. clearly seemed worried that, without some form of criminal immunity, former presidents would be vulnerable to partisan warfare as their successors used the courts to go after them once they were out of office. And that, he added, could lead to endless cycles of retribution that would be a risk to stable, democratic society. Justice Ketanji Brown Jackson appeared more concerned that if presidents were in fact shielded by immunity, they would be unbounded by the law and could turn the Oval Office into what she described as the seat of criminality. What happens next? There did not seem to be a lot of urgency among the justices, especially the conservative ones, to ensure that the immunity question was resolved quickly. That left open the possibility that Mr. Trump could avoid being tried on charges of plotting to overturn the last election until well after voters went to the polls to decide whether to choose him as president in this election. And if he is elected, any trial could be put off while he is in office, or he could order the charges against him dropped. It could take some time for the court to do its own analysis of what presidential acts should qualify for the protections of immunity. And even if the justices determine that at least some of the allegations against Mr. Trump are fair game for prosecution, if they do not issue a ruling until late June or early July, it could be difficult to hold a trial before November. That would become all but impossible if the court took a different route and sent the analysis back to the trial judge, Tanya S. Chutkan. If Judge Chutkan were ordered to hold further hearings on which of the indictment's numerous allegations were official acts of Mr. Trump's presidency and which were private acts he took as a candidate for office, the process could take months and last well into 2025.